Hello, hello. So if you guys can all stay up for our discharge upgrades presentation, I would appreciate it. So just to tell you a little bit about some of my clients. Mr. L was a Ranger who served for 13 years for our military service. He had 6 deployments to Iraq and Afghanistan. After his 6th deployment, he came back with severe PTSD, and the psychiatrist in service prescribed him an anti-anxiety medication. The medication caused him to get more depressed. He went back to his off-base home, closed the doors, and sat in his house for 81 days. He was deemed AWOL and received an other than honorable discharge. Mr. C was raped repeatedly by a fellow service member during service. He told his chain of command, and they refused to do anything about it. He had a series of AWOLs for trying to escape his perpetrator. He has been 100% service-connected for PTSD related to MST from service. He currently has an other than honorable discharge and cannot receive compensation for his PTSD, only treatment. Lastly, we have Mr. M. So Mr. M had childhood PTSD that was aggravated by service. In service, he had a suicide attempt. He was court-martialed for intentionally trying to hurt himself to avoid duty. He had a second suicide attempt and was given an other than honorable discharge. This is why I am starting the National Discharge Upgrade Program to pair pro bono attorneys with veterans with traumatic brain injury and post-traumatic stress disorder to combat their other than honorable discharges and give them the benefits and compensation they deserve. Once again, my name is Danica Gonsalves. I'm an Equal Justice Works Fellow, sponsored by AT&T and Aiken Gump. So I'm going to play a short movie about how an other than honorable discharge can affect a veteran's life.
The thought of military veterans without medical or mental health care seems like a bad dream, but it happens. For many who leave the U.S. military with less than honorable discharges, including thousands who suffered injuries and anguish in Iraq, Afghanistan, and elsewhere, standard veterans benefits are off limits. The discharge serves as a scarlet letter of dishonor, and the effects can be severe. Ex-military members with mental health problems or post-traumatic stress disorder can't even turn to Veterans Affairs hospitals or clinics. Those who want to go to college aren't eligible for the GI Bill. The jobless get no assistance for career training, and the homeless are excluded from vouchers.
As we've been hearing all day, an other than honorable discharge significantly affects these veterans' lives. Not only do they receive no benefits, but it acts as a scarlet letter. When you apply to a general job application, it asks on the bottom, did you serve in the United States military? You check yes on that box. The next question is always, were you honorably discharged? When you check no, it is the equivalent of a felony, and a lot of these members cannot get jobs. In addition, they don't get any recognition to be a veteran. They're not allowed to have state-issued veterans cards, and they don't even get a burial flag, despite having served in combat. And this is why it is important to get them a discharge upgrade. A discharge upgrade, as we've heard all day, does bar you, not necessarily, but can bar you from VA benefits. So many of these service members are coming out of service with traumatic brain injury and post-traumatic stress disorder and cannot get treatment and cannot get compensation for their injuries that sustained in service. This is also a vulnerable population. They are 7 times more likely to be homeless, more likely to be in the criminal justice system, and twice as likely as honorably discharged soldiers to commit suicide. We are trying to create an army of pro bono attorneys to help these individuals apply for a discharge upgrade. And what you are going to learn today is how to put together the best application you can for your client. So there is going to be a little bit of a repeat, so I'll go through these next slides pretty fast because we've already talked about them. But the VA defines a veteran as an individual who was discharged from the active service under conditions other than dishonorable. This doesn't necessarily mean if you only have a dishonorable discharge, you get barred from benefits. They use this language to bar individuals with other than honorable discharges as well. We've heard a little bit about COD reviews earlier today. About 75 to 90% of veterans with other than honorable discharges are denied benefits. There are 6 different types of separations. There are Administrative and punitive. On the administrative side, there's 3 different types. We have an honorable discharge, which is generally when they complete their full enlistment contract, a general discharge, the other than honorable discharge. On the punitive side, these are the discharges you get as a result of a sentence from a court-martial. There's bad conduct, dishonorable discharge, and dismissal. So I'm not going to be talking about dismissal today. We don't normally see officers with other than honorable discharges, so we're going to focus on enlistees. So I'm going to do a really brief run-through of what the definitions of these separations are. Every single branch has their own definition for each type of discharge. So when you are going through a discharge application, it's really important to cite to the regulation and the language that that specific branch uses. Because what you're trying to do is argue that your client met that standard. So honorable discharge is when someone's service was a quality that meets the acceptable conduct or is otherwise so meritorious that any other discharge would be clearly inappropriate. A general discharge, and this is very important to note, is a discharge where, though they had generally positive service, there are some negative aspects that outweigh the positive aspects. People that receive general discharges are not eligible for the education bill. This is very, very, very important to know because when you get your client a discharge upgrade, 97% of the time, they're upgraded to a general discharge. They still do not qualify for education benefits. So when you are speaking to your pro bono client, you need to explain to them that even if you receive a favorable discharge upgrade, they are likely still not going to be eligible for education benefits. And other than honorable discharge is meant for individuals where the basis of the discharge was the commission or omission of an act that constitutes a significant departure of the conduct expected. As we're going to see later in the presentation, a lot of this misconduct can be tied to a mental health disorder like PTSD or traumatic brain injury. There is a process to be administratively separated. They do have to go through notice, counseling, they get written documentation. You do have the right to fight your administrative discharge, though at that point, many people, especially if they're suffering from a mental health condition, will just waive away all their rights and take the other than honorable discharge just to get out. Go roughly through the bad conduct discharge. This is meant for repeat offenders of small offenses. Like I said earlier, to get a punitive discharge like a bad conduct, it has to be the result of a court-martial sentence. And lastly, the dishonorable discharge. This is meant for service members who are convicted of offenses that are akin to felonies. Okay, so now we're going to get into the important stuff. So this is a copy of the DD-214. Who has seen the DD-214 before? Awesome, almost all of you. Okay, so this is the release, the certificate of release from active duty. I would like them to all be the same, but they're not. They're different formats, the boxes are different places, but there are some important things to note. When you first are trying to get a discharge upgrade application, the first form you want to look at is the DD-214. You're going to want to look at how much time they have in service. Obviously, if you have an individual that has 3 years and 11 months active duty, they are more likely to try to get an upgrade than someone that might only have 7 months. So note how much time that they have and when they served. When I get a DD-214, I look at when they served because that means I'll know if they were during a war era. If they're during the war era, there might have been the possibility of combat. In this section, you'll have their decorations and awards and medals. Those are things you should beef up and emphasize. If your guy has a Purple Heart, put it in bold. He has a Purple Heart. You really want to put your client in the best light possible. These are advocacy pieces. Write your client as if you were trying to put them on the highest pedestal. Pretend they're your kid. Everybody loves bragging about their kids. This is someone, they're your child. We are going to brag about them. Make sure that you know all of their medals and awards. Remarks can be anything as in they served during combat, etc. Generally at the bottom of the DD-214, though, like I said, the format kind of changes sometimes in the middle, is the character of discharge. This is where it would say if they got an honorable discharge, general discharge, other than honorable, etc. Something also to note is the narrative reason of separation. This is generally written on the DD-214, and it can be very stigmatizing. Some of the different types of narrative reasons you'll see is pattern of misconduct. If they have a failed urinalysis, it will say drug abuse. They could have in lieu of court-martial, personality disorder, homosexual acts, or for the convenience of the government. So when you're doing a discharge upgrade application, you should ask your client if they also want a narrative reason change. If they have drug abuse on their DD-214, you might get it upgraded to a general, but that's still pretty stigmatizing when they hand it to their employer that they were kicked out of the military for drug abuse. So like I said, when you are doing a discharge upgrade, ask them if they want to change in that narrative reason. Different branches treat other than honorables differently. It depends on the culture and depends on the regulations that apply. As you can see from the chart, the Air Force only gives 0.5% of their service members other than honorable discharges, while the Marines, 10%. Think about that. 1 in 10 Marines receives an other than honorable discharge. These are the guys in high competitive and dangerous missions and are commonly exposed to more stressors, and they are the ones being kicked out. So there are 2 different boards that you can go to apply for discharge upgrade. Luckily, discharge upgrade terminology is not that hard. There are like 4 buzzwords, that's all you need to know. There are 2 boards. You have your discharge review boards and your board for correction of records. Every single branch has their own discharge review board. Besides the Navy and the Marines, they're combined into the Naval Discharge Review Board. They gain their authority from 10 U.S.C. 1553. You must apply to the Discharge Review Board within 15 years of being separated. So if you have an Iraq or Afghanistan veteran, you're most likely been going to the Discharge Review Board. If you have a Vietnam veteran or Gulf War veteran, they cannot go to the Discharge Review Board. It's very, very important to know because a lot of veterans get denied on their discharge upgrade applications because they sent to the wrong board. So you'll have a Vietnam vet that accidentally sends his application to the Naval Discharge Review Board. It takes them a year to even get to his application. They see it, goes to the wrong board, automatic reject, send it back. He just lost a year. It's very, very, very important to give the application and send it to the right address, to the right board. There are 2 different types of reviews that they do at the discharge review boards. There are a records review and a personal appearance hearing. It's kind of interesting because there is a way to get 2 bites of the apple at the discharge review boards. You are allowed to first apply for a review on the records, and if you receive an unfavorable decision, apply for a personal appearance hearing. However, if you apply for a personal appearance hearing first, get an unfavorable decision, you cannot then go for a records review. And we'll actually talk about personal appearance hearings and how to best go about them. Almost all of them are in the DC area. I believe only the Air Force still has a traveling board, but just plan on them being in the DC area. The government does not reimburse the veteran to go to the personal appearance hearing. So if you are not in the DC area, then that's something to explain to your veteran that they will have to pay their expenses to go to DC for this hearing. The boards assume that the discharge was proper. The burden is on the applicant to provide substantial and credible evidence that the discharge was not proper. Most veterans apply on their own. They do not understand that they have the burden of proof. Most applications get rejected because they take the form and write, "I deserve a discharge upgrade," and they send it off. They provide no evidence, they make no argument, these are automatically rejected. You have to make an argument, and that is why it is so important to get attorneys involved on these applications. We're trained to make arguments. We actually like making arguments. It's kind of why we went into law. So to be able to use our skills that we have developed to help them will substantially increase their chances of getting a discharge upgrade. So when you go to the review boards, you do need to get a majority vote. There are 5 officers that are on the board at each time, so you must get at least 3 to be able to get a discharge upgrade. The 2 buzzwords that you need to know with the discharge review boards is you have to provide substantial and credible evidence that the discharge was either improper or inequitable. Improper literally means improper, so there must be a prejudicial error of fact, law, or procedure. So it must be prejudicial, meaning had the error not occurred, there is substantial doubt the veteran would have received the same type of discharge. There are errors that occur but it wasn't prejudicial to the client, this would not be an adequate argument for the board. You also can have a retroactive change in policy enacted. The only time I've seen that apply would be for like the don't ask, don't tell repeal. There was a lot of people that received other than honorable discharges with homosexual acts on their DD-214. It has been explicitly stated that these need to be changed, and that would be an example of a retroactive change. But improper means improper, error, fact, or procedure. So for example, of impropriety, this doesn't happen that often, as vets know, and others that are currently serving active duty. Military has lots and lots and lots and lots of regulations, and they do usually pretty good at adhering to them, so you're not going to see that many improper discharges. So when we're talking about discharge upgrade with mental health, they're mostly going to be on that inequitable side. For an example, on an improper though, I have one veteran who was hospitalized for suicidality in service and was recommended for discharge. When they sent the packet up to his commanding general, they forgot to add the portion about his mental health and that he was in a psych ward at the time. And so they gave him an other than honorable discharge. We actually were able to have that officer write an affidavit that said that the separation packet was incomplete, and had he seen the mental health information, he would have given a general discharge. This rarely happens, but that would be an example of impropriety. What we normally are going to be arguing is inequity. So with inequity, you need to show that one of three things. One, that current discharge policies are materially different than those that led to the discharge. Going back to the prejudice, there must be substantial doubt that had those policies been enacted at that time, the person would have received the same discharge. One great example of this is if you have Navy or Marines. So last year, SecNav introduced this dual processing type of discharge. If you are diagnosed with a mental health condition in service, and they're also separating you administratively for misconduct, they must now do what's called dual processing. They have to send you to the admin board and a med board, and they're going to do a balancing test on whether the mental health condition outweighs the misconduct. This was just enacted last year. So if you have any Navy and Marines that were discharged prior to 2016 and had a mental health condition that was diagnosed in service, you can use that new policy to argue, had they been discharged today, they most likely would have received a general discharge because they would have recognized the mental health condition. You can also show that the discharge was inconsistent with disciplinary standards. This is also a pretty rare argument. Like I said, the military likes adhering to their standards. And the last is based on evidence of service. This is where we use mental health conditions. There are 3 directives that talk about how to write a discharge upgrade application when you have a veteran with a mental health condition, and we'll review those. But this is where you can show that there were mitigating factors that led to the discharge, such as traumas that occurred, family problems, or, as we're going to emphasize today, a mental health condition. If, and only if, hopefully this doesn't happen, you receive an unfavorable decision from the Discharge Review Board, you can apply for reconsideration one of 5 ways. The first is if a personal appearance hearing, as I said, you can do a records review, and then a personal appearance hearing. Second, if there was discharge upgrade policies that were retroactive, and those can apply through the 3 directives that we're going to be talking about in a little bit. If the policies then were materially different, those would also be the 3 directives. And also if there's new, substantial, and relevant evidence. So if you have a vet that filled out the form, mailed it in, and said, I deserve a discharge upgrade, provided no evidence. He's actually diagnosed with mental health conditions. There's tons of evidence that show the mental health condition was in service, and you now have them, and it's still been less than 15 years. You can reapply to the Discharge Review Board with substantial and new evidence. Any questions about the Discharge Review Boards before we go on? Perfect. All right. Okay, so next there's the Board for Correction of Records. There are 3 different types of boards here, so you need to look and make sure you send it to the right branch's boards. I'm going to call them collectively the BCMR, or Board for Correction of Military Records. This is the board you apply to if it's been over 15 years. So a lot of the veterans that are coming to us are Vietnam and Gulf War veterans. This would be the board that you apply to. So they have a little bit of a different terminology they use for their discharge upgrades. They can correct an error or an injustice. However, unlike improper and inequity, these aren't defined anywhere. So it left advocates with this kind of guessing game, but what they have found is that they use similar arguments as the impropriety, inequity. So when you're looking for your arguments, you can go back to those two standards. As same with the discharge review board, they're going to assume that the discharge was proper. The burden is on the applicant to provide substantial and credible evidence that the discharge was an error or an injustice. The very odd thing about the Board for Corrections military records is that they actually have a 3-year time limit to apply from the discovery of the error, which you're thinking, okay, well, obviously it's been more than 3 years. Luckily, they routinely waive this in the interest of justice. There has been those 3 directives that explicitly say that if you are claiming a mental health condition as a mitigating factor, they have to waive the 3-year statute of limitations. But on the form, there is a box that says, has it been longer than 3 years? If so, is it in the interest of justice to waive it? You can just write, per this directive, you're required to waive it. So as I said, there are 3 different directives that apply to applicants with a mental health condition. The first one was the Hagel memo in 2014. We have a Carson memo in 2016, and then there was a new directive that came out this year in August of 2017. So the 2014 Hagel memo changed the ball game for discharge upgrades. In 2013, the Army Board for Corrections and Military Records only upgraded 3.7% of applicants' discharges. In 2015, after the Hagel memo, that number for applicants with PTSD or traumatic brain injury rose to 45%. This is why it is important now to get pro bono attorneys involved. These are actually being upgraded for applicants with a mental health condition, but they need to make an argument and they have the burden of proof. A lot of these people are very vulnerable. They're disabled, they have a severe mental health condition, and they need our help to write these applications for them. The major point of the Hagel memo was that the boards must liberally consider that the mental health condition mitigated the misconduct. What was difficult here is the directive did not define liberal consideration. So though the board do have a higher rate now, they have still fiddled with what liberal consideration means. And that is why it was very, very, very important that this 2017 new clarifying guidance came out. In 2017, just in this August, the clarifying guidance came out, 5 pages long, on what liberal consideration means. They said, boards, specifically, you need to look at 4 questions. First, does that veteran have a condition or experience that may mitigate or excuse the discharge? If your client has a diagnosis from a licensed psychologist or psychiatrist, this is evidence of a condition. If you have a client that doesn't have a diagnosis, if they allege a diagnosis, the board must liberally construe that to mean they have a condition. But I always recommend to have your client evaluated and get that diagnosis rendered by a licensed psychologist or psychiatrist. 2, does that condition or experience occur during military service? If you have the licensed psychiatrist or psychologist tie it to service, this will be liberally construed as existing during service. If they're already service-connected for the condition, that's persuasive evidence. So just like the first question, make sure you have a diagnosis before applying. 3 and 4 is where they really need the advocate's help. Does that condition or experience actually excuse or mitigate the misconduct? And this is where the balancing tests come in. What they're now asking the boards to do is if it's reasonably determined that the condition existed during service, they must liberally construe that as mitigating evidence. So kind of think of the discharge upgrade like a sentencing hearing. You really want to put forth all these mitigating factors that played into the misconduct so you can get your client a lesser sentence. So this is where, like I said, they really need advocates' help showing that the misconduct was actually mitigated by the condition. One really easy way to do this is to get a letter from the psychologist or psychiatrist that they have a condition, that it was exhibited during service, and the misconduct is tied to their condition. The last, does the condition outweigh the discharge? What they're going to do here is a balancing test. They do know that there are conditions like PTSD or traumatic brain injury that do mitigate misconduct, but sometimes the misconduct is so severe it doesn't completely outweigh it. Or what they have determined is premeditated misconduct is not outweighed by a mental health condition. They did explicitly say that substance abuse will not be considered in that definition. So those substance abuse and substance seeking behaviors is premeditated. They're not going to consider that outweighing the misconduct. So now that we have that clarifying guidance and the global consideration, the directive explicitly states that mental health conditions inherently affect one's behavior and judgment. The Department of Defense is now recognizing how a mental health condition can play into a service member's service record. They also stated that an honorable discharge does not require flawless service. It only requires that the person served honorably and faithfully. They also talked about how misconduct can change over time. What they specifically stated was, alluded to was marijuana use. So back in the 80s, the military looked really harshly on marijuana use. Now with changes in state laws and potential federal laws, they said explicitly that marijuana use is now less severe. Also now, just like that SECNAV memo that requires the dual processing, they also recognize that service members today receive heightened screening before their discharge, especially if they have just come back from deployment. They are going to screen them for a mental health condition before they discharge them. People before probably like 2015 did not have that luxury. So you can argue that since I have a Vietnam veteran, they absolutely were not screening for mental health conditions back then. So had he served today, he would have been screened, they would have recognized that he had PTSD, and he would not have received this other than honorable discharge. So how to use these guidance? So there are the 4 questions. We're gonna go back to your first year in law school. Do you guys remember Iraq? Okay, well if you don't remember it, it's issue, rule, application, conclusion. You are gonna write these briefs the same way you write every legal brief. You are gonna take the issue, take the rule, the application to the facts, and conclusion. The issue is that you have a service member who participated in misconduct but has a mental health condition that can reasonably be stated as mitigating. The rule, you find the directive that applies. Literally, take the text, stick it in your brief. That is your rule. They have given us the rule, they gave us the directive, it has the rule in it. Next, what you're doing is you're using your law skills and applying that rule to the facts of the case and having a strong conclusion. So we're going to go through one example on how to use the Iraq method. So you have Mr. Doe. Mr. Doe was a Vietnam combat veteran. While in combat in Vietnam, he experienced lots of trauma and developed PTSD. Once he finished his deployment, he came back stateside and started having nightmares, panic attacks, and started drinking heavily, and then went AWOL. What we are trying to show is that Mr. Doe's mental health condition, his PTSD, not only mitigates misconduct, but it actually caused the misconduct. So your issue is that Mr. Doe's PTSD mitigates that 30-day AWOL that led to the other than honorable discharge. Next, we pull out the rule. So per the 2014 Hagel memo, in cases where PTSD may be reasonably determined to have existed at the time of the misconduct, those conditions will be considered potential mitigating factors in the misconduct. Then we apply the facts to the rule. So Mr. Doe's psychiatrist has diagnosed him with PTSD and wrote a letter saying that his AWOL was due to his PTSD symptoms. You would use those facts and apply it to the rule. You would show that he has a diagnosis, go through your 4 questions. Does he have a diagnosis that may mitigate or excuse the misconduct? Yes. He has a diagnosis, PTSD, that is evidenced by his psychiatric diagnosis. 2, did it exist during service? Yes. His psychiatrist explicitly tied his PTSD to his experiences in service. 3, does the condition and experience excuse or mitigate the discharge? And that's where like I said, they need our help. We are arguing that it does. PTSD affects your judgment, affects your behavior, and he went AWOL because of his symptoms, and his misconduct, a 30-day AWOL, is outweighed by his PTSD symptoms. Then you want to end with a strong conclusion. So his application squarely falls within the directives. Because of his PTSD and the severity of his symptoms, this outweighs the 30-day AWOL, and this warrants a discharge upgrade to a general under honorable conditions. So at a personal appearance hearing, each board kind of has their own style. So I have personally been to the Army Discharge Review Board and the Naval Discharge Review Board, and they run them completely different. But as far as being an attorney and being an advocate, it's pretty close to the same. What you want to do, think of it like a court setting. You want to develop a theme to your case. So like Mr. Doe, our theme is that he has PTSD, his PTSD symptoms cause the AWOL, the PTSD mitigates the misconduct. Re-emphasize that theme all the time. You give an opening statement, give your facts and story, stick to your theme. Next, you're going to give the applicant is going to have the chance to talk. So this is going to be your veteran. I prefer to have them do a free-flowing narrative. I let them talk. I let them tell their own story. This will develop compassion from the board, and they get to see your veteran as a human. Next, the board will then do a question and answer, and they will kind of drill your veteran, so it's really good to prepare them. If anyone has any detailed questions on personal appearance hearing, feel free to contact me or talk to me afterwards, and we can discuss it more in depth. You can also offer character witnesses, whether that be a family member, a friend, or an employer that can attest either to their mental health condition or to their service. And next, you give your closing statement, which once again would stick to your theme. So discharge upgrade decisions can be appealed to federal court system. They are generally appealed first to the district court, and this would be the district court in DC or the district court where the veteran resides. That who has jurisdiction over this. They are under the APA, which we have alluded to earlier, which means that you must show not that the service and their decision was arbitrary and capricious, but literally that the 2-page decision you got was arbitrary and capricious or abuse of discretion. This is a very, 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 very high standard. If the court can make any connection between the decision and the facts, they're going to rule in favor of the board. So not many of these cases are appealed to federal court, but it is a possibility. So to write a discharge upgrade application, I'm going to take you through the step-by-step. So first you would interview your client, find out if you have a potential case. Then you're going to gather your records. We've talked about record gathering today. It's tedious, takes a long time, and you must make sure you're sending it to the right place. And then you prepare the application and submit it. So most of you guys work with veterans, so I probably don't need to talk to this. I usually present to private attorneys who have never talked to a real human in a while. But you really need to hone into those interpersonal skills when you talk with your veterans. I always introduce myself by my first name. I like going on a first name basis with my clients. I think it builds that trust and builds that sense of connection. Learn the lingo. We've learned a lot of lingo today. Never call a Marine a soldier. They will not like you. They might drop you as an attorney. So make sure you're calling them by the right name. And they also might talk in terms like use like Article 15, NJPs, et cetera. Ask them, if you don't know what they're talking about, ask them. You really need to understand their story, but make sure you build that trust with the client. As far as interviewing about their trauma, when I do my initial intakes, I don't ask about the details of the trauma. A lot of people don't like going into it, especially not right off the bat. And when it comes down to it, it doesn't matter. All I'm looking for is that timeline. So what you usually have is you have an exemplary soldier, goes into combat, suffers MST, suffers other types of trauma, and their performance goes like this. I don't necessarily need to know the details of that trauma. All I need to know is that trauma happened around this time, and that's what caused the decline. Once you build that trust, they might want to open up about more details, but I have one client, I still don't know what happened that day, but when it came down to it, it really didn't matter because we were able to show that timeline. Record requests like I said, take forever right now. SF1As are taking 5 to 8 months to get your response. So prepare your client, let them know it's gonna be a really, really long process. It's not gonna be something that happens overnight. And make sure you send a record request to the right agency at the right location, because otherwise it will significantly delay your application. And also it is important to request post-service mental health records, because like I said, you do wanna show that the veteran has a diagnosis. Other evidence that you can use to supplement your application would be like pre-service evidence. What we're seeing a lot of right now is undiagnosed childhood PTSD that's aggravated by service. A lot of service members come from bad homes. They suffer from childhood abuse and they go into service with undiagnosed PTSD. When they get into service, they suffer a lot of stressors, which then exacerbates their symptoms and leads to the misconduct. So sometimes it is useful to show childhood trauma. From service, you're going to absolutely need to get their entire personnel file, because like I said, the applicant has the burden. If you apply without knowing what's in their file, you can't rebut it with substantial and credible evidence. So before you ever file a discharge upgrade application, make sure you have their entire personnel file. We've talked about buddy statements when we're talking about VA claims. That can help substantiate stories and also show good service. Post-service evidence would be like mental health records, if they've completed rehab. If they turned their life around, also talk about that. If they came out and then started a nonprofit that helps veterans, play that up. Let them know that they're giving back to their community. So the application should include the form. With the discharge review boards, it's the DD-293. The Board for Corrections Military Records is the DD-149. Make sure you use the right form. Make sure you send it to the right address. I cannot stress that enough. And when I do my briefs and when I teach briefs, do it like you would a court brief. Have a cover page, a table of contents, a list of exhibits, petition for relief, discussion, and a conclusion. So here are some examples. These are small examples, so I'm going to use some of my real life examples of some of my clients. So I have one client who developed severe PTSD, had been serving in the Navy for 13 years. And his PTSD led to meth use. He was having major severe nightmares and did not want to go to sleep. He knew if he went to sleep, the nightmares would come back. So he started using meth so he would not go to sleep. He would wake up the next day, have to use meth again because he was so tired because he didn't sleep, and it led to a continual use. He developed an addiction. After 5 failed urinalysis, he received an other than honorable discharge. He had served in the Navy for 14 years. I have another individual. She went to Iraq and Afghanistan, hit by an IED, suffered from traumatic brain injury and post-traumatic stress disorder, shattered her back and her rib cage. She was in Walter Reed for 6 months. They sent her back and had her take an other than honorable in lieu of court-martial. These are the types of veterans that we need to help. We can use our legal skills to write briefs for them to get them discharge upgrades. It's not that difficult. There are only, like I said, 4 buzzwords. You have the 2 boards, Discharge Review Board, Board for Correction Military Records. Was there an error or an injustice, or was there improper or inequity? We're usually going to be arguing an injustice or an inequity based on health conditions. You use the clarifying guidance. With each question, make it a new subheading in your brief. Issue rule application conclusion. When we write these strong briefs, we can get these veterans a discharge upgrade and get them the benefits and compensation they were promised and deserve. When you submit the application, it also takes forever. Like everything in this system, right now, applications are taking about 1.5 years. So this is something to talk to your veterans about. Let them know, like I said, this is gonna be a very long process. If you have any questions or comments, feel free to reach out to me or the consortium. And thank you. We really appreciate you willing to serve our veterans. The veterans appreciate it, and we can come together, use our legal skills, and really help them get the upgrades they need. Does anyone have any questions? I know you don't want to be that person. Yes. Yes.
If you get a discharge upgrade for someone that has the rated PTSD, then they get back pay from the VA for that time?
So for the VA, the benefits always goes to the date of application. So what I have my clients do, when I take them on as a client and I'm going on the discharge upgrade route, I have them file an initial claim that same day. I'm like, go right now, e-benefits, file for PTSD, because they still can only go back to the date of application per regulations. But if you have them do it and they get a, right now COD reviews are taking around average over 3 years. So you can actually get a discharge upgrade faster, which is a little sad, but if you have them file, when they're doing the COD, if you get a discharge upgrade, then it will still go back to that date of application. But they're not going to get retroactive pay. Any other questions? Yes.
What is the pro bono awareness that will make veterans here on the road?
You can be on my list, and I can give you clients. So you're welcome to join the discharge upgrade program through the Veterans Consortium. Like I said, we're starting a nationwide program to pair pro bono attorneys with veterans with other than honorable discharges. All of cases that we give out are already screened for merit, so you know that when you receive a case through our program that there is an argument to be made.
I think he was asking if he can send people to you.
Oh, absolutely. Send anyone. I love talking to veterans. Any other questions? All right, I'm excited to see all your emails flooding in talking about discharge upgrades. And let me know if you have any questions about service dogs.
All right, thank you all for coming.